Back in 2012, Parliament legalized private parking tickets. Parliament's intention was to protect businesses that own land, or customer car parking from people parking their cars without permission. Instead, it has spawned a multi-billion-pound industry, bringing misery to millions of people, with a small minority of companies profiting from that misery. In this video, we show you how you can legally use the law to defeat the enforcement of private parking tickets, and, in some cases, you can get costs paid out to you from the private parking company. In 2012, Parliament introduced private parking tickets, or what they call parking charges. We show you how you can use the law to defeat the enforcement of private parking tickets, and in some cases, use the law to get costs paid to you from the private parking company. First, we need to explain the law behind private parking tickets. The law is Schedule 4 of the Protection of Freedoms Act 2012, which states,
recovery of unpaid parking charges. The driver of a vehicle is required by virtue of a relevant obligation to pay parking charges in respect of the parking of the vehicle on relevant land, and those charges have not been paid in full.
And Schedule 4 also defines a parking charge to be,
in the case of a relevant obligation arising under the terms of a relevant contract, means a sum in the nature of a fee or charge, and in the case of a relevant obligation arising as a result of a trespass or other tort, means a sum in the nature of damages. However, the sum in question is described.
So, that means, the parking charge is merely a sum payable for compensation for a breach of contract. The law also defines relevant contract.
Relevant contract means a contract, including a contract arising only when the vehicle was parked on the relevant land, between the driver and a person who is the owner or occupier of the land, or, authorized, under or by virtue of arrangements made by the owner or occupier of the land, to enter into a contract with the driver requiring the payment of parking charges in respect of the parking of the vehicle on the land.
That means, the law allows landowners, or their appointed contractor, to recover a sum from the driver of a vehicle, for parking on land without permission. The landowner may use a third-party contractor to enforce private parking, and it is a commercial decision by the contractor to carry out the work. So, the private parking company has to make a profit. If you have received a private parking ticket, which must be attached to your vehicle, or handed to the driver, then that is an invoice for the use of the landowner's property. The law does not state that the charge must be reasonable, or the actual loss paid by the landowner, so they can use these rules to make a profit, and some private parking companies have taken it to a whole new level. In 2015, the High Court in London ruled in the case of Beavis v Parking Eye, that a charge of £85 is not unconscionable. In this judgment, the court heard.
On the 15th of April 2013, Mr. Beavis parked in the car park, but overstayed the 2-hour limit by almost an hour. Parking Eye demanded payment of the £85 charge. Mr. Beavis argued that the £85 charge was unenforceable at common law as a penalty, or that it was unfair and unenforceable by virtue of the unfair terms in Consumer Contracts Regulations 1999.
The Court of Appeal upheld the first instance decision rejecting those arguments. That means private parking companies can charge £85 for parking on private land. And, this judgment has emboldened private parking companies to indiscriminately increase their charges, and thus increase profits. So, what do you do if you get a demand? We are going to show you how to protect yourself from the liability, and make it commercially uneconomical for the private company to bring proceedings to recover the money. And, how to protect yourself from getting private parking ticket demands in the future. When you get your first demand, it's usually a simple request for payment. If you ignore that letter, 30 days later, you will get another demand, this time, a very threatening letter. Another 30 days, you get a vigorously worded threatening letter. After that, two things can happen. Nothing. Or, they bring legal action. A parking company has to think very carefully about starting proceedings. It costs them money, which they cannot recover if the claim fails. So, it's a gamble, and they look at whether any of their reminder letters have achieved a response from you. If you replied to a demand, then the parking company knows they have a live case, and knows where the debtor lives, and has acknowledged the debt. the parking company is almost certainly going to start proceedings. Some parking companies use common debt collectors. A street debt collector, unlike bailiffs, have no legal power to enter homes or take control of goods. So, they start telephoning you. They get your mobile number from the DVLA, because it is the number you put on the V5 new keeper slip when you bought your car. Other parking companies may take the risk, and start proceedings in a county court. The parking company relies on you not responding to the claim, so that they get a default judgment. So, if your intention is not to pay the private parking ticket, you must never ever respond to any correspondence sent by the private parking company, otherwise, you cannot apply to the court later to set aside the judgment. This is an example of a county court default judgment. It states at the top of the document, highlighted here, and says,
in default.
This is where things can get messy. The debtor now has a county court judgment. So, we are going to show you how to get rid of it. And this procedure applies to any default county court judgment. Civil Procedure Rule 2310 states,
application to set aside or vary order made without notice. A person who was not served with a copy of the application notice before an order was made under Rule 23.9 may apply to have the order set aside or varied. An application under this rule must be made within 7 days after the date on which the order was served on the person making the application.
And Civil Procedure Rule 23.9 states,
service of application where application made without notice. This rule applies where the court has disposed of an application which it permitted to be made without service of a copy of the application notice. Where the court makes an order, whether granting or dismissing the application, a copy of the application notice and any evidence in support must, unless the court orders otherwise, be served with the order on any party or other person against whom the order was made, and against whom the order was sought. The order must contain a statement of the right to make an application to set aside or vary the order under Rule 23.10.
That means, if the county court judgment is a default judgment, which again, this example is highlighted here, then you may apply to the court to have the judgment set aside. The rule also stated that evidence in support must be served, so you must give evidence that you had no previous knowledge of the court proceedings. The most common reason is you have changed address, or moved, or you have been working away. If you show evidence that you were at a different address from the address on the default judgment, then you can apply to the court to set the judgment aside. The evidence must show you did not live at the default judgment address, such as a bill, a screenshot of your online banking, driving license, or a tenancy agreement. It doesn't matter what the evidence is, or where it came from, but so long as it shows a different address from the default judgment address. The parking company can apply for the hearing to be listed, as there was never a hearing in the first place. But there is a drawback for the parking company. They must pay the hearing fee into court within 14 days. And, if they don't pay the hearing fee within 14 days, the court will automatically strike out the claim, and the judgment against you is cancelled, and you may recover your costs from the parking company. Civil Procedure Rule 3.7 states,
sanctions for non-payment of certain fees by the claimant. This rule applies to fees payable by the claimant where the fee payable for a hearing specified by the Civil Proceedings Fees Order 20,081, Fees Order 2008, is not paid. If the claimant does not pay the fee, the claim will automatically be struck out without further order of the court, and the claimant will be liable for the costs which the defendant has incurred unless the court orders otherwise.
So, if you have unpaid private parking tickets, now you have a way to deal with them, and make some money as costs, from the private parking company. Your costs can include damage to your credit rating. This can include having to pay a higher rate of interest for the whole term of a mortgage or loan, than you would have otherwise paid if the parking company had not damaged your credit rating. The parking company cannot litigate you again for the same claim on the same set of facts, so you are off the hook for the debt, and the parking company is left to pay their court fees. If a parking company does try to take you to court again, then you can apply to the court to strike out the claim for an abuse of process, and ask for your costs. Civil Procedure Rule 3.4 says,
power to strike out a statement of case. The court may strike out a statement of case if it appears to the court that the statement of case is an abuse of the court's process. When the court strikes out a statement of case, it may make any consequential order it considers appropriate.
We hope you have learned something new today, so why not share this video? Dealing with Bailiffs offers free online advice for people with bailiff-related problems, and a telephone helpline to help you recover damages for enforcement impropriety. Until then, if in doubt, keep 'em out.